Your will not automatically avoid the probate process. When you pass away the will and assets in your personal name, they will have to go through the probate process before they can be distributed out to your family. And so in this video, we're going to talk about the probate process with a will. We're also going to talk about strategies on how to avoid the probate process depending on the types of assets you have and who you're passing them out to. Now, the probate process with a will looks like this. You pass away, your executor will have to go find your original will. They cannot just go grab copies. So it's important that they know where your original will is before you pass away. They will take your original will, your death certificate, and a petition for probate, file those documents at the probate courts in the county where you lived. And then the probate courts will open up the probate process and give them letters of testamentary, which gives them the authority to manage the assets inside of the estate. And then at that point, they have to publicly notify creditors that you have passed away. The way that they do this is to put a notification in the local newspaper once a week for a 4-week period. And this gives the creditors the ability to come to them and say, hey, this individual owes us money for these debts that they had. And then it's your executor's responsibility to pay those debts off. Now, once they have the letters of testamentary, they can go to the financial institutions, your utility company, your property tax assessor, etc. And they can say, hey, this individual has passed away. I have the letters of testamentary, meaning I'm in charge of the estate, and I want to either take the money out of the bank accounts and put them into the estate bank account, or I want to start making payments on the mortgage, on the utilities, on the property taxes, on HOA, etc. And so it's their responsibility to take care of all of those assets that you have and make sure that they are properly maintained. Now, once they have been notified that there are debts that need to be paid off, they have to pay these debts off with the assets inside of the estate. The first thing they're going to do is take your liquid assets and try to pay those off. This would be things like your checking, savings, investment accounts, etc. And then if there are not enough liquid assets to pay off those debts, they will move on to physical assets, which would be things like your home, your car, a boat, motorcycle, etc. They will sell those assets, generate cash, and then pay off those debts. Now, if there's not enough assets inside the estate to pay those debts off, it will literally wipe out all of the assets inside the estate. If there is money left over after paying off the debts, then they would distribute the remaining assets or money out to the beneficiaries per the instructions in that will document. And so the will does not avoid probate. All it does is give instructions on how those assets should be distributed. Now, in terms of avoiding the probate process, we have a couple different options depending on the assets we have and who we're passing them down to. For real estate, it could either be our spouse or our kids. And so for our spouse, a good setup is to own it as joint tenants with rights of survivorship. It's common that the default ownership style is tenants in common. When you own a property as tenants in common, even though you're married and you co-own it together, it will have to go through the probate process when you pass away to be able to be distributed out to your spouse. If you hold it as joint tenants with rights of survivorship, all they have to do when you pass away is file a survivorship affidavit and your death certificate at the county clerk's office, and then it will avoid the probate process and be distributed directly out to your spouse, and they will own 100% of that property. Now, in terms of your kids, you can either co-own that property with your kids, or you could set them as a designated beneficiary. When you co-own the property of your kids as joint tenants rights of survivorship, you're exposing yourself to their liabilities. You are avoiding the probate process, but their liabilities could be things like divorce, lawsuits, creditors, etc. And you may be forced to sell your property while you are alive to pay off those liabilities so they can pull equity out of that property because they own it and is exposed to those liabilities. Now, you can set up a transfer on death deed, which will allow you to maintain full ownership of that property while you are alive and name them as a designated beneficiary. That way, you are not exposing yourself to those liabilities. And when you pass away, all they're going to have to do is file a survivorship affidavit and a death certificate at the county clerk's office, and it will avoid the probate process and be distributed directly out to them. So that's how you handle real estate. If you want to handle your financial accounts, this would be things like checking, savings, investment, retirement, life insurance, etc. You can name designated beneficiaries on those accounts. And then what is going to happen is when you pass away, they will take your death certificate to those financial institutions. They will give them those documents, and then they will distribute that money out to those designated beneficiaries and avoid the probate process. Now, if you want to account for all of your assets and you want to control how those assets are being managed and distributed, you can put them inside of a revocable trust. The benefit of this is going to be that when you pass away first and then you have a surviving spouse, you can keep those assets inside the revocable trust and use them to take care of your surviving spouse for the remainder of their life. And then they won't have to try to figure out how to manage the finances while they're in the final stint of their life. You can set up one of your children or a friend, a family member, etc., to manage those assets on behalf of your surviving spouse. That way they are benefiting from those assets, but they're not in, they don't have the responsibility of figuring out how to manage them, especially if you're the one that manages the finances in your household. The other benefit is going to be that you avoid the probate process 2 sets of times. And so the way we like to set up revocable trust jointly is that the assets will stay inside the revocable trust to take care of their surviving spouse through the rest of their life. Then when they pass away, those assets get distributed out to the kids. And so when you pass away, it avoids the probate process and stays inside the revocable trust. When your spouse passes away, it avoids the probate process and gets distributed out to the kids. Now, when your assets are going through the probate process, it can take 1 to 2 years depending on the complexity of your estate, and it can cost $5,000 to $15,000, again depending on the complexity of your estate. So you're saving your spouse and your kids potentially 1 to 2 years each time, and then 5 to 15 grand each time as well. And so it's much easier to set up all of your assets to avoid the probate process. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.